Oh, you don't want us to cuddle?
Awesome, thank you, appreciate it.
Okay, I think it's time. So we have this annual commemoration of Constitution Day, and this is pursuant to a mandate, an unfunded mandate from the federal government. Well, it's funded in the sense that if you take federal funds, which we do, because we accept federally funded student loans, then you have to have something on the Constitution in and around every institution of higher education has to have something on the Constitution in and around Constitution Day. Constitution Day is actually this Friday, but because that was not too many students here on Fridays, we decided to have it today. And at this hour, basically because a couple of the panelists couldn't make it at noon, and also to allow for at least the participation of. Why am I doing this? The rule is that when we're at the podium, we can lower our masks, okay? I wish I could extend that generally, but, the institution will allow it. But in any case, so welcome to Constitution Day. It turns out we do have some snacks back there, which is courtesy of our dear students. We used to have this thing, and sort of faculty would talk about the Constitution, but I thought that was, the fact of the matter is, between Francis, Ruco, and myself, we kind of have this cast of all year on constitutional law, so I think you've heard enough, or you'll hear enough about it. So I thought it'd be rather interesting to hear from some of the people who've been through constitutional law and have something interesting and maybe provocative to say. So without further ado, I'm going to introduce Patrick Walsh, who was in my final class last year. He's a third-year day student. And then he will be followed by John Johnson, who will address the question of the constitutionality of coded mandates by government. So, Patrick, we will take over.
So, I was asked to speak last Thursday for today, and I accepted. And I was asked to talk about the constitutionality of the COVID lockdowns and the vaccine mandates. So I figured I would talk about the research I've been doing for a firm, which is challenging the vaccine mandates for medical workers. And so the first question I thought was important was, where does this power come from in the Constitution? Well, the answer is it's really not in the Constitution. It comes from before the Constitution. It's the police power of the states. That's what the governors are using to implement these lockdowns and these mandates. It's for the sake of public health and safety. This power existed before the ratification of the Constitution, when the states were just sovereigns, kind of like a king or a queen. But it's become more embedded in case law since then. The seminal case that I was able to find, funny enough, it's from Massachusetts, Boston Harbor, Commonwealth v. Alger, was the first time this police power was mentioned, I believe. In that case, Mr. Alger built a dock on his waterfront property that exceeded the statutory limit that our state legislature had established, which was 100 logs. Not really sure what a log is, but it makes sense to me, I guess. They cut his dock off at 100 logs, and he sued got all the way to the Supreme Court, and the United States Supreme Court ruled that the United States Constitution is the only limitation on the plenary power of the states to police and regulate themselves for the public's health and safety. Since then, our jurisprudence has pretty much adopted this idea, and the states have pretty much unlimited power outside the Constitution. There is somewhat of a debate going on because of the 10th Amendment, which reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved for the states respectively, or to the people." And it's really that last line, "or to the people," that causes a bit of debate, because some people argue that we have retained some of these rights and powers and we haven't given them to the states yet. And some argue that the legislature is the representative of the people, and that this is that way of incorporating these powers. It's an interesting thing to keep in mind as you study common law. It may come up again. Vaccine mandates, like those envisioned today, have been challenged before. In Commonwealth v. Jacobson in 1905, a man and his son challenged a vaccine mandate for a smallpox vaccine in Cambridge. It was a regional mandate. If you lived in Cambridge, you were required to get vaccinated for the smallpox then, or you were subject to a $5 fine, which today is $100. Jacobson made it all the way to the Supreme Court challenging this law because he refused to get vaccinated. He had had bad reactions to other vaccinations in the past, and same with his son. The court held there that the statute mandating the vaccine was valid, and that Jacobson had to pay the fine or face the jail time that came with not paying the fine. The reasoning of the court was that the state had the power to mandate such things during emergencies or a pandemic. Then it was the smallpox, now it's COVID-19. And essentially they said that the individual's liberty could be impinged for the good of the entire population or the community. There were no exemptions offered to this statute, like a religious exemption or anything. One of the quotes I thought was interesting to bring up, because they cited Commonwealth versus Alger, "The good and welfare of the Commonwealth, of which the legislature is primarily the judge, is the basis on which the police power rests in Massachusetts." So once again, we're talking about the Commonwealth's, the good of the Commonwealth versus the individual's liberty, who's outweighed in this situation. The court interestingly held that the state could not force the Jacobsons to be vaccinated, but they could subject them to the fine or the jail time afterward. Moving on, I would like to discuss a more recent challenge to the vaccination mandates. Hunter Harris and Cora Cluett versus the University of Massachusetts Lowell in Boston, which just was settled on the 27th of August, not even a month ago. In this case, Harris challenged the vaccine mandate put in place by schools like ours. He didn't even have a religious exemption. He was just morally against this, and that was outweighed by the state interest. However, Cluett had a religious exemption, and she claimed that she was Roman Catholic, and that was against her religion to be vaccinated. So the Dean of Student Affairs at UMass Lowell, DeVoe, did a little research and unilaterally determined that this exemption was not valid by referencing the U.S. Conference of Catholic Bishops, which made a statement that the vaccines are morally justified in their religion. These reasons, coupled with the fact that the 11th Amendment precludes suits against states and the arms of the state, like UMass, was the basis for their decision to dismiss the students' claims and to deny the injunction just under a month ago. And this raises a good question, in my opinion. Should a government entity be allowed to interpret religious beliefs? And there's a case that kind of speaks to that, and it was in 1981. It's Thomas versus the Review Board of Indiana Employment Security Division. Thomas was a worker at a sheet metal factory, and the sheet metal factory changed into a tank turret, a machine gun turret manufacturing facility. Mr. Thomas claimed that this was against his religious beliefs. He was a Jehovah's Witness. He didn't want to take part in creating any armaments or weapons. And he struggled with this belief, and eventually he quit because the employer would not offer him any other position. He ended up filing for unemployment, and he was denied because he voluntarily left the position, and he sued in court saying that he was being discriminated against for his religious beliefs. He made it again to the Supreme Court, and the court held that the government cannot compel a person to choose between participating in a public program over their religious beliefs without a substantial burden on their right to free exercise. This burden could only be overcome by a governmental interest of the highest order, along with the action being taken being of the least restrictive means possible. So I have a question that I would like to leave you all with. So does COVID-19, that spreads quickly with a recovery rate of 97 to 99.75%, constitute an interest that is of the highest order, which would justify shutting down the majority of the economy and society in general, mandating vaccines, and punishing those who do not obey these orders? And is this the least restrictive means of going about this? Secondly, if this is an interest of the highest order, in your opinion, and someone loses their job because of a closely held religious belief that they should not vaccinate, does this hold the employers liable for religious discrimination under Title VII and Massachusetts General Laws 151B, which is our anti-discriminatory statute? These are questions that the courts must now grapple with, and that's what I leave you with today.
Hi, there's so many of you here. I think we should maybe give a thanks to Dean Quinn for making this a PILF-approved event, because nothing gets students to show up like a PILF-approved event.
What about free food?
Free food is absolutely always good. We already did a thank you to Dean Cahill, but a thank you a second time just not hurt at all. So something I was particularly interested in when they asked me to come and talk about this is Joe Biden. He recently started this 6-point strategy for how he was going to deal with COVID-19. And one of the prongs of this plan is to obviously vaccinate those who are unvaccinated. And part of that is an emergency temporary standard by Osha, which will inevitably affect 80 million workers in the private sector. So I think that we needed to ask at least a question about this. Is this action constitutional? And what are the little parts about administrative law here that are impacting this? I'm a TA for Common Law, and I'm also a TA for administrative law, so I tried to combine the two issues to see what is really going on here. And because OSHA is an administrative agency, I think that there are parts of that. I did bring my Constitution with me because I do want to talk about this, but let's first frame the issue in case some of you slept under a rock this week. But on September 9, 2021, Joe Biden has asked OSHA to draft an emergency temporary standard that mandates business with more than 100 workers to require vaccinations against COVID-19 or face weekly testing, and that business offers employees paid time off to get vaccinated. So that's what he's asked OSHA to do. And I think that's always important when we're talking about what is a president asking the administrative agency to do, to first say, well, what did he actually say to them? And I think there are 2 points of the Constitution that I highlighted that I wanted to bring up. So obviously in the preamble, we are providing for the common defense, promoting the general welfare, and securing the blessings of liberty. So obviously we could at least think that maybe the Commander-in-Chief has some responsibility to secure the general welfare, and part of that may be requiring the people who are unvaccinated become vaccinated. So let's start with that, but there's another part. It's the vesting clause. So where does the power come from to make laws? The legislature, and only one legislature, is granted and vested in a Congress of the United States. This is often referred to as the delegation doctrine. The legislative powers are delegated to Congress. Now, you may be wondering, what about OSHA? OSHA, if they're making a regulation, it does have the force of law. It does seem to affect people and their liberties and their property, especially this action that OSHA is going to be conducting is definitely going to affect people's liberty, because there is no decision whether or not to get vaccinated. There's kind of a decision, but it's kind of complicated, and it forces people to get tested once a week, and I think that is at least an imposition on their liberty. So there's definitely a question here of whether or not OSHA is even allowed to do this, but what the Supreme Court's jurisprudence has said is that administrative agencies are allowed to make laws, but there's a limit, right? And that is where you have an intelligible principle. So has Congress actually told OSHA in a way that is intelligible that they are allowed to conduct this activity? The place where we look for this is the Enabling Act for OSHA. OSHA's Enabling Act is the Occupational Safety and Health Act, often referred to as the OSHA Act. And it was drafted by Nixon, or it was enacted by Nixon in the 1970s. So we're talking about a pretty old statute. And their act, basically, when you're talking about enabling acts, you want to see what is the agency's purpose? Why have they been established? And OSHA's purpose is to enact and create safe working conditions by authorizing standard working practices. So they've been told to make the workplace safe. Now, if they're being told to make the workplace safe, is COVID one of these things that we have to make sure we eliminate from the workplace? I think that it's probably impossible to say that we would actually eliminate COVID entirely, but that's just my opinion. So we're talking about an emergency temporary standard, so we need to first have a ground rule for what an emergency is. And an emergency is a situation, according to Black's Law Dictionary, which requires immediate attention and remedial action. So COVID-19, where it is right now, isn't an emergency. This is a question that legislatures are going to have to ask. So if the legislature has given OSHA the power to make workplaces safe, and OSHA is now acting on this power under this emergency temporary standard, maybe these vaccinations are constitutional. But does the president then get to decide what all emergencies are? Should maybe Congress be doing this instead? And I think that the way I wanted to describe this is by saying I think presidents maybe make really, really, really bad decisions sometimes, and I think that sometimes they do it based on what's politically popular. And I want to go back one president ago to Donald Trump, because Donald Trump, he also saw an emergency. He saw an emergency on the southern border. In his opinion, they had to stop the flow of illegal immigrants, and that was an emergency that had to be stopped immediately. This was litigated by the ACLU in the Ninth Circuit Court of Appeals, and in that case, they ruled against Trump pretty clearly in the Ninth Circuit, saying that it was an unlawful use of funds, and it was not the emergency to which the funds were promised. And to quote the senior staff attorney with the ACLU, he said, "The courts have once again confirmed what everyone knows: Trump's fake national emergency was just another pretext for targeting immigrants and border communities." So the question that I wanted to leave with you guys as we reflect on the Constitution is whether or not we want just the president to decide what an emergency is, or whether Congress should be doing this. And is OSHA really the place where we want to have all these decisions made about our liberties? That's what I wanted to leave you with, and just a little food for thought. Thanks for having me.
So I would like to introduce my two students from common law. They're the evening students. They're represented why we're so proud of our evening students. They bring a lot of experience. Both of these students were in common law last year. Both of them have full-time government jobs with the government that are law-related, and work full-time and are able to come and help us tonight. So the first person is Mark Conforto, who's going to discuss the Afghanistan issue from a military point of view. And the second speaker is Kaylin Hilliard, who is going to speak about the plight of women who are left in Afghanistan. Thank you.
All right, so as Professor Rucko said, I am Mark Conforto, and I'm going to present on some constitutional considerations during the war in Afghanistan. kind of give just a very brief overview of some of the more defining actions taken by our government during the past 20 years during the war in Afghanistan, which invokes certain articles of the U.S. Constitution, and also to consider whether or not our government has been operating within the limitations of the Constitution during this 20-year war. All right. So the first issue that I came up with was the legal basis for the Afghanistan War. So shortly after the terrorist attacks on September 11th of 2001, President Bush declared that Osama bin Laden and al-Qaeda were responsible for organizing, planning, and carrying out the attacks. In order to hold these people responsible for the events on 9/11, the United States made the following demands to the Taliban, who at the time were the de facto government of Afghanistan. We demanded that the Taliban must surrender all leaders of al-Qaeda, to include Osama bin Laden, to the U.S. government. We demanded the release of all foreign nationals being held by the Taliban government. We demanded that they close down all terrorist training camps immediately within the borders of Afghanistan, and to hand over all terrorists and their supporters to the authorities. They also give the United States access to these terrorist training camps within Afghanistan to ensure that they cannot be operated any further. The Taliban obviously declined to accept these demands, claiming that there was no connection to be proven between al-Qaeda, Osama bin Laden, and the 9/11 attacks. So on October 7, 2001, the United States began combat operations to remove the Taliban from power in Afghanistan, and this would be the start of America's longest war. However, there was no formal declaration of war made by the United States. Article 1, Section 8 of the United States Constitution states that the Congress shall have the power to declare war. Therefore, the President does not have the unilateral power to start wars and must seek the approval of Congress. The War Powers Resolution of 1973 was passed into law by Congress to limit the President's power to commit U.S. forces to armed conflicts without the approval of Congress. The resolution set clear criteria on when and how the President could send U.S. troops into combat. There's 3 criteria that the President could commit troops to engage in war. First, the President could only deploy troops to combat when there's a declaration of war approved by Congress. Second, if there's a statutory authorization allowing the President to send troops into combat. Or lastly, in the case of national emergencies created by an attack upon the United States, its territories or possessions, or its armed forces. Congress had passed the War Resolution Act as a result of the Vietnam War as a way to prevent the President from engaging in lengthy military engagements short of a declared war, and also as a means for Congress to reassert their constitutional power regarding wars given the near disappearance of the practice of actually declaring war. The last time we declared wars in World War II, any conflict going forward was not through a declaration of war through Congress. So on September 18th of 2001, the United States Congress passed the Authorization for Use of Military Force Resolution. This granted the President the authority to use all necessary and appropriate force against those whom the President determined had planned, authorized, committed, or aided the September 11 attacks, or harbored those responsible for the attacks. So this resolution provided the President the statutory requirement needed under the War Powers Resolution of 1973 to legally commit U.S. troops to Afghanistan. So while there's never a formal declaration of war made against Afghanistan by Congress, the President's unilateral decision to begin combat operations against the Taliban had been authorized by Congress, and we argued this was within the intent of Article 1, Section 8 of the United States Constitution. So the next constitutional issue that came up during the Afghanistan War was extraordinary rendition. So what is extraordinary rendition? This is essentially government-sponsored abduction and extrajudicial transfer of a person from one country to another. So why does the United States engage in this? So the purpose behind extraordinary rendition is to circumvent the specific laws of a country regarding interrogation, detention, and torture. In the case of the United States, the government will render an individual to a third-party country which does not have strict laws on torture or detention. Our government argues that the individuals rendered are aliens who are detained outside the United States and therefore do not have any constitutional rights. Specifically, the government has claimed the Fifth Amendment right to due process does not extend to non-U.S. citizens who are extradited and tortured abroad. So an example of this is the case of Khalid al-Mazari, who's pictured there. Al-Mazari is a German citizen who was born and raised in Lebanon. In December of 2003, while on vacation in Macedonia with his family for the holidays, he was detained by local police after his name matched that of a known al-Qaeda terrorist who had allegedly been involved in planning the 9/11 attacks. The Macedonian police contacted the CIA regarding this match, and upon being released by the Macedonian police a few days later, the CIA agents immediately took al-Mazari into custody. Al-Mazari was then stripped, hooded, shackled, and dressed in a dye-burned jumpsuit and with total sensory deprivation, he was flown to Baghdad, Iraq. From Baghdad, he was then brought to the salt pit. This is a CIA black site located in Afghanistan. While in Afghanistan, al-Mazari was repeatedly beaten and interrogated. After being held for approximately 2 months, CIA officials realized they had the wrong person and that al-Mazari was simply a case of mistaken identity. However, the CIA still refused to release him from custody. In March of 2004, al-Mazari, while in custody, went on a hunger strike, demanding his due process rights to go before a court to address his unlawful detention. After 27 days without eating, al-Mazari was finally able to meet with the CIA site director in Afghanistan, who admitted to him that they had the wrong person and that he was completely innocent. Nevertheless, the CIA still refused to release him from custody. Al-Mazari continued his hunger strike for an additional 10 days before they force-fed him by officials. In April of 2004, the CIA director, George Tenet, was informed by the CIA operators in Afghanistan that al-Mazari was innocent and that he was being wrongfully detained. However, the CIA still did not release him from custody. His eventual release did not occur until May 28th of 2004, 6 months after when he was first arrested, and this only occurred after National Security Advisor Condoleezza Rice became aware of the detention. It took 2 separate orders from Condoleezza Rice before he was actually freed. And instead of returning al-Mazari to Germany where his family was, they flew him out of Afghanistan, brought him to Albania, and then dumped him at night on a road in the middle of nowhere with no explanation, apology, or resources to get home. In 2006, al-Mazari attempted to sue the CIA in the United States District Court, Eastern Division of Virginia, under the Alien Tort Statute for violations of his constitutional rights. He specifically claimed that the CIA violated his Fifth Amendment right to due process because the CIA contravened the Due Process Clause prohibition against subjecting anyone held in United States custody to treatment that shocks the conscience or by depriving a person of liberty in the absence of legal process. The district court granted the government's motion to dismiss on grounds claiming the state secret privilege was valid, and that given the application of the privilege here, the motion was valid and needed to be granted. Al-Mazari appealed, and the Fourth Circuit Court of Appeals affirmed the trial court's decision, holding that the case was properly dismissed on the state secret grounds. So I think people need to ask themselves, is this representative of who we are as a country? Is this representative of our Constitution? Next slide. Next slide is on the indefinite detention of unlawful enemy combatants. So what is an unlawful enemy combatant? So this is actually defined by statute in the United States. It's essentially explained as any person who's engaged in hostilities or who has purposely and materially supported hostilities against the United States and is not a lawful enemy combatant. A lawful enemy combatant is considered any member of the regular forces of a state engaged in hostilities with the USA, members of a militia or volunteer corps wearing a uniform or insignia, or any member of a regular armed force who professes his allegiance to the government engaged in hostilities with the USA. So since 2002, since the beginning of the Afghanistan War, over 770 detainees have been held at Guantanamo Bay. Currently, there's about 39 remaining there. 27 of those have not been charged with any formal crimes. Some detainees have been held for almost 20 years without any charges. An example of that is Abdul Latif Nassar. He was brought to Gitmo in 2002 from Afghanistan and never formally charged with any crimes. He was only recently released in 2021, and approximately 30% of the detainees at Gitmo are from Afghanistan. An important case is Rasul v. Bush, 2004. In this case, it explains that after the September 11th attacks, Congress authorized the use of force against the terrorists responsible for 9/11. Rasul and other defendants were captured in Afghanistan during the ensuing campaign there. The defendants were held at the U.S. military base in Guantanamo, which is Cuban territory, but there's a lease that gives the United States jurisdiction over that area. So the defendants' relatives challenged the detentions by claiming the defendants are innocent, but have not been charged, allowed to talk to an attorney, or even access courts. The United States District Court for the District of Columbia deemed that these filings to be a habeas corpus petition. They dismissed their claims for lack of jurisdiction. The United States Courts of Appeals for the District Court of Columbia affirmed, and the United States granted the cert on this. So the issue before the court here was whether federal courts have jurisdiction to hear habeas corpus petitions by foreign nationals held at Guantanamo Bay. Justice Stevens held that yes, the federal courts are within their jurisdictions and may hear habeas corpus petitions by anyone claiming to be illegally incarcerated under U.S. law Historically, the courts have been authorized to hear habeas petitions by aliens during wartime. The issue is then whether the habeas statute authorizes review of the executive detention of an alien in an area where the United States has exclusive jurisdiction but not total sovereignty. The court compared this case to Johnson v. Eisentrager, where there was no habeas jurisdiction was found in cases involving enemy aliens who were captured, tried, and convicted by a military tribunal for war crimes and incarcerated, where all events occurred outside the United States. Unlike the petitioners in this case, the defendants are not citizens of a nation at war with the United States. Defendants claim they are innocent, have not been charged or tried, and are being held in the United States exclusive jurisdiction. Contrast that to Eisentrager, the court was construing the constitutional and statutory rights of habeas corpus. Any general principle against extraterritoriality of the law is inapplicable to the habeas corpus statute. Under the lease, the United States has potentially perpetual exclusive jurisdiction over the base. And American citizens held, they would be entitled to a habeas corpus review. But the habeas corpus statute does not exclude non-citizens, so federal habeas corpus review has long been available to aliens held in even exempt jurisdictions where other actions were not. So the district court has jurisdiction over these defendants as custodians, and they should hear the challenges of the legality of the incarceration under the habeas corpus statute. So Justice Scalia did dissent in this, and he claims that this case plainly contradicts the rule set Eisentrager. He believes that the court's rule here opened the door to a floodgate of litigation by millions of prisoners at a great cost to the military and the impediment of the war effort. He believes Congress should have logically amended the habeas corpus statute if it wants to, and here the court shouldn't be doing that. So that essentially completes my presentation. These are things that I think we should think about anytime we're engaging in war, where we talk about nation building and spreading democracy and whether we're actually upholding our constitutional rights, and if we're actually imposing those on other countries, or if we are simply doing the same thing we accuse our enemies of doing. So if there's any questions or concerns, comments? And that I'm all done.
Hi everyone. Again, my name is Kaylin Hilliard. I'm presenting on the plight of women in Afghanistan today, and just keeping in mind while you're listening to my presentation, if you've had common law, what rights our Constitution affords us as United States citizens. If you haven't taken common law, I'm sure you already know some of the rights that the Constitution affords us. And think about, as I go through my presentation, what these women are going through and what rights they are not being afforded as citizens of their country. So I want to start out with a quick story about a woman that is currently in Afghanistan. So late one afternoon in August 2021, Shakira heard a banging on her front gate. In the Sangin Valley of the southern province of Afghanistan, women must not be seen by men who are not related to them. And so her 19-year-old son, Ahmed, went to the gate to see who was there. Outside were two men in black turbans carrying rifles. They were members of the Taliban who are waging an offensive across the countryside of Afghanistan to gain control from the Afghan National Army. And one of the men said to Ahmed, "If you don't leave immediately, everyone is going to die." Keep in mind, this is not even a month ago. So Shakira, who is in her early 40s, corralled her husband and her 8 children, and their family walked through their village past dark and vacant houses, except for wandering chickens and orphaned cattle in the community. The village was completely empty. Now Shakira's family walked for hours under the blazing sun, and she started to feel the rattle on the ground of the distant thuds of the distant thuds of action and combat going on. She saw people continue to leave their villages on her track, and men were carrying all that they could bear to carry that they didn't want to leave behind, and women were quickly running as fast as they could in their burqas. Now, the pounding of the artillery fire in the air started flashbangs in the sky. This was a Taliban assault on the Afghan army outpost. So Shakira and her family continued their journey through U.S. abandoned bases where snipers were nested and there were barren lands potentially filled with explosives. So Shakira and her family were trying to make it to the city of Lashkargah, which remained under the Afghan government control. But even if they reached the city, Shakira wasn't sure what she and her family would find there. Since the start of the Taliban's blitz, the Afghan army soldiers had surrendered in droves, begging for safe passage home. And it was clear that the Taliban would soon reach Kabul, which is the nation's capital, and that 20 years of war and trillions of dollars later, devoted to defeating the Taliban, had come to this point. So Shakira's family stood in the desert discussing their next move. The gunfire sounded closer, and Shakira spotted the Taliban vehicles racing towards them. And she decided to stay put. She was weary to the bone, and her nerves were frayed. She would face whatever came next and accept it like a judgment. She said, "We've been running all of our lives, and I'm not going anywhere." So to understand the full picture of how Shakira and many other women in Afghanistan ended up in this situation that they face today, let's go back and travel back in time to the early history in Afghanistan. So let's go back to the 1920s in Afghanistan. In 1920, women were afforded the right to vote in Afghanistan, notably the same year that women were afforded the right to vote in the United States. There was an emancipation of women at this time in the country for decades to come. In 1923, women were allowed the opportunity to marry on their own accord, and in the 1940s and 50s, women were becoming teachers, nurses, and doctors. And in the early 1960s, women enrolled in the university and began to flood the workforce in vast numbers. And even by 1963, women were entering sports in Afghanistan. From 1966 to 71, 14 women were appointed as judges to the courts of Islamic jurisprudence in Afghanistan. Then we jump to the Soviet Union's invasion of Afghanistan in 1979, which is when a communist government was installed. The communists were a repressive government of political dissent, but they did promote women's rights at this time until they lost power in the late 1980s. During this time, when the Afghan citizens were fighting the Soviet Union, Afghans formed the Mujahideen, which is a rebel group that rose up on the basis of Islam to free their country from oppression. And at this point, the United States had provided funding and aid to the Mujahideen to beat the Soviet Union and drive them out from gaining another satellite stakehold in the Middle East. At this time, there was a strong fusion between politics and religion. And the country was in turmoil not only with the Soviets, but with each other. There were 7 Afghan party leaders that gained traction, each of which were represented by different ethnicities and tribal groups, and they were separated between moderates and fundamentalists. So by the time the Soviets left Afghanistan in 1989, the United States had ended their aid to the Mujahideen, and the 7 leaders began jockeying for power. The withdrawal of the Soviets in Afghanistan left no political settlement, which immediately led to civil war. And during the Civil War, women's rights were an early casualty at the time. Women's rights to freely mobilize and go about their own day in the country were reduced because of the war, and educated Afghan women were fleeing their families to refuge in neighboring countries, and some even migrated to the West. The education sector at this time was decimated, and the formerly upward trend that we saw from the 1920s to the 1970s had begun to downward spiral. Thank you. And at this point, during the Civil War, a new group in Afghanistan won the battle after the Soviets left. This group was called the Taliban. They emerged as a force that would do good and bring peace to the country. At first they did because they drove out all the petty warlords in the country, but this meant monumental changes for women in their rights in their country. The Taliban immediately imposed gender apartheid rules over women. Under the Taliban rule in the 1990s and early 2000s, women were told to leave their jobs and stay home. They were stripped of their rights, not allowed to leave their homes unless accompanied by a male relative, and they were fully dressed in head-to-toe burqas. Girls were banned from going to school, women were imprisoned, tortured, and executed for moral crimes such as prostitution or infidelity, and they were commonly whipped in the streets by the Taliban police for showing skin on their wrists or their ankles. Taliban were the meanest, toughest guys in the town, and they brought the civil war in Afghanistan to an end, but imposed a type of medieval kind of peace on their society. After the United States invaded Afghanistan following the September 11th terrorist attacks, they embarked on an ambitious effort to encourage and even impose broad reforms that touched all aspects of society in Afghanistan, including politics, economics, education, defense, and societal roles between men and women. So the United States helped and had significant influence over the 2004 post-Taliban Constitution in Afghanistan, which afforded and gave many Afghan women more rights than they had under the Taliban rule. So this is the articles of the Afghan Constitution, and just think about how they may relate to what we have in our country. So Article 22 of their Constitution states, any kind of discrimination and distinction between citizens of Afghanistan shall be forbidden. The citizens of Afghanistan, man and woman, have equal rights and duties before the law. Article 44 of the Constitution allowed the government to implement effective programs to create a balanced education for women. And then another article, Article 53, adopted necessary measures to ensure that women without their caretakers were allowed to receive necessary medical services. And also Article 84 of this Constitution allowed the Afghan president to appoint at least 50% of women to the House of Elders, which is in essence like our House of Representatives in the legislature. It didn't reach 50%, but that's what the Constitution said. Since this adoption of this Constitution, there's been a flourishment of rights afforded to women, and there are as many as 800 organizations in the country for women's rights. Many of these organizations have launched services to assist women, such as in literacy training, health, and skills training. There were important also and I'm speaking the past tense now that the Taliban is in control, there were important legal reforms underway, such as a new family law code and criminalizing violence against women. At that time, after the adoption of the Constitution, girls' schools were reopened, even though there was a dire shortage of women teachers and not a great education sector in Afghanistan. And to look at the monumentous change in education, in 2003, there were fewer than 10% of girls enrolled in primary school But in 2017, that number had grown to 33%. By our standards in America, that's not a lot, but in Afghanistan, that's a huge change. 3.5 million Afghan girls were in school, with 100,000 studying in universities. And importantly, the picture on the left are women serving in the House of Elders in Afghanistan. By 2020, 21% of Afghan civil servants were women, compared to essentially none during the Taliban years, and 16% of those women in civil service had risen to the level of senior management. There was a female candidate for president, and there was a female governor in a province in Afghanistan. While the 2004 Constitution created a centralized government that provided many benefits for women in Afghanistan, it is also the downfall of this nation, because the form of government that the Constitution provided did not prove to be much benefit or of success in this country. So when the United States went in to create this Constitution, they modeled it much like our own, where there was a highly centralized national government, rather than in Afghanistan that where the government had previously run was based on a regional autonomy, which better reflected how things, like I said, were previously run. And the Constitution in Afghanistan that the United States helped create also rejected a parliamentary system in favor of a presidential system like we have here. And this kind of government, as we know, is fosters a winners take all posture amongst politicians, the legislature, and the executive branches. However, in Afghanistan's pre-Taliban rule and during the Soviet occupation, Afghanistan had always embraced a method of having regional or tribal elections, and that's how they ran their politics. So this between the fragmented voting laws from the Constitution and the government not working itself, this created an unstable coalition of politicians not being able to band together and yet effectively get things done for the country. And in essence, this further led to instability. And many people in Afghanistan, the voters, were left confused of their options of who to vote for. There was no coherency amongst government officials. And this foundation that was unstable, and in this government structure that was founded upon ideals that did not work for Afghanistan and its people, led to the demise of the Afghan government, and is now what we have today, the Taliban rule. So, in the wake of the Taliban takeover in Afghanistan over the past few months, fears are growing that Afghan women will suffer the sort of harsh treatment that they faced under the Taliban rule back in the 1990s and early 2000s, where the Taliban imposed their hardline interpretation of Sunni Islam. Taliban officials have offered assurances since they've taken over the government that women would be allowed to go to work, and in some cases travel without their male relatives. But the Taliban had made these statements before, back in the 1990s, after they took control over the capital of Kabul. Now what we have here, in this situation happening now, women's safe houses, women's family guidance centers, and children's homes have all been closed in a matter of days after the Taliban took over Kabul on August 6th. On August 24th, the Taliban told women to stay home, which would be a temporary measure, but women in government positions have not been allowed to return to their jobs, and some women in TV have been forced into wearing modest clothing or forced off air altogether. And the Taliban hasn't yet formally announced what its government structure would be, but for now it'll be run as a 12-male member council comprising of men, most of whom have not ever had a seat in government before. on September 3rd, a small group of Afghan women protested the new rulers outside of the presidential palace in Kabul. And around 20 women gathered outside this presidential palace with microphones under the watchful eyes of the Taliban gunmen who allowed the demonstration to proceed. But a few days later, on September 9th, the Taliban began to use whips and sticks to hit this group of women while they protested and chanted, "Long live the women of Afghanistan." And 3 days later, on September 12th, the Taliban announced that women would be allowed to study in gender-segregated universities. And on Monday, just 2 days ago, the Taliban announced that they were imposing a black hijab mandate amongst all women across the country. Can you actually go back to the slide? Thank you. This is a picture in a university in Kabul where women students are wearing their black hijabs in their full veil. And so there was a former faculty member at the American University of Afghanistan who tweeted a picture of this and said that no woman has ever dressed like this in the history of Afghanistan. This is utterly foreign and alien to Afghan culture. We must dispel the information that is being propagated by the Taliban. So as you see here, the women of Afghanistan have a long, dark road ahead of them, and their humanitarian plight is a reminder to all of us here today that we should be grateful that we have a constitution that promotes life, liberty, and the pursuit of happiness. And we must keep all these women in our thoughts and prayers, and all of the people in Afghanistan in our thoughts as they move forward into an uncertain time, not knowing what's ahead. Thank you.
I think now we have time for student comment, participation, questions for our panel. I think we've only really got 10 minutes because people have to go. People have class, but maybe I can recognize you and you can address it to any or all of the your comment or questions to any or all of the panelists. Well, come on. And
Yeah, my question is for Pat and Davon. Of course it is. So my question is, when you talk about the risks of COVID and the overall minor percentage of fatalities from it, when weighing the risks of public health versus personal liberty, where do you calculate all of the people who are suffering from long-term health effects, even though they are still alive? People who now are permanently disabled, who have developed heart and respiratory problems that will ultimately lead to an earlier death than they would have otherwise had. And when you consider that, the small percentage still incorporates millions of people, at what point, how many human lives, I guess, would it take before we weighed that more heavily than money, I guess?
Yeah. That was my statistic, yes. I would have to say that's subjective, and I think that 5 Supreme Court justices would be the decider of that matter. The language of the highest order, I think, speaks volumes to the governmental interest that would be required to counterbalance anyone's individual liberty on the fact or their rights. Yeah.
I don't know, Sam, I think I would probably add, I don't think it's a number for me. I think it's more just who is actually dealing with the problem and can that person actually be held accountable? I had described that Osha is the one that's kind of taking the lead on this. Osha is not elected officials, right? So they're appointed by the president. That's how they get there. And the president is elected every 4 years. But the president isn't supposed to be the one making laws. The president is supposed to be the one enforcing them. And those are the laws that are devised by Congress, who are responsible to us, every 2 years sometimes. Obviously, there's different types of that, but generally they're responsible to us every 2 years. And so when there are these really big things that happen, they can be more responsible to us quicker, and we can respond to the legislative action. So I don't think I have a problem with the mandate as far as it's to promote the general welfare. But what I do have a problem with is people doing things that they are not empowered to do. And I don't know, I don't think OSHA is really the place where this should be happening. I don't know how many doctors work at OSHA, maybe a lot do, but I do think that was maybe something for the CDC, but I know the CDC's kind of been doing a lot as well, and they're really not supposed to be in the workplace. So I think this probably should have been something done by Congress. This could have been a legislative thing, but I think nobody probably wanted to do it, and if they did, they probably would have had to convince people, and people in Congress aren't really interested in convincing people anymore. So I think that's just them not doing their job, and that doesn't mean that we can then just throw away the Constitution. This is a republic, and after all, we're celebrating the Constitution right now, so that's a hard part to answer your question.
Thank you.
Anyone else? Come on, don't be shy. I know you've all got the buzzers. Yeah.
This question for you, I'm sorry.
Oh, shoot.
Okay, so it's really just maybe about your research a little bit. I'm wondering with OSHA, is there something about 100 employees that you see come up with their rules? I'm just wondering where the number 100 employees comes from. Why not like 50 or 10 or every?
I don't know where they came up with 100 from. I think that was actually not OSHA that came up with it. I think it's actually the president's directive.
Okay.
So I don't know if you heard President Joe Biden's speech, but basically he said, he laid out his entire plan, and the plan was if a company, particularly, has 100 or more employees, then they will need to vaccinate, or the employee will have to submit to the weekly testing. But I don't think this is OSHA, because this is actually the president telling OSHA what to do.
I have a question or comment, I guess, which is apparently with respect to this mandate, right, of vaccination or weekly tests, right, that the president is imposing, I think, by executive order and by charge to OSHA, I guess. Congress itself and its employees, its staff are exempt from this.
Yeah, there's a whole host of exemptions. One of them is the post office. So postal workers were exempt.
Well, apparently now postal workers are covered, as I understand.
I thought they were exempt.
No, originally they were exempt, but I think they patched that.
There's a bunch of union exemptions as well. So like if you're part of a union, certain kind that's
Right. So I guess my
fairly
question to everybody is, what do you think of the idea that there be general rules promulgated where Congress is itself exempt from these rules? Does that make sense to you, or Caitlin, do you have any thoughts on this, or Mark?
I mean, it sounds like it's making a class of people that are exempt, and that's not a good thing, right?
Yeah, I mean, yeah.
Simply put, it seems like rules for thee, but not for me. And I don't think that's correct.
I mean, my sense is habitually Congress will exempt itself from laws that it passes for others, and I just wonder about the wisdom of that, just given that supposedly they're writing general laws, right, and therefore they should be in principle applicable to everyone, and maybe there's our cases for exemptions, but I don't think they should be systematically exempting themselves, or so I would argue.
I mean, I think the thing that I think is important is that the reason we're doing this is because it's an emergency, and I'm not a doctor, but I'm not going to say that it's not an emergency. I'm not going to say that it is. But my thing is well, if this is an emergency, why are there exemptions, and why are certain people exempt and certain people aren't? And I mean, if something is a medical exemption, that seems different, but just by status, that seems not different.
So I just want to comment that, like, from my perspective at least,
Yeah.
the idea that Congress could establish a law for the people and thereby exempt themselves establishes a dangerous precedent. And that dangerous precedent is that Congress is above the law because they do not have to follow that same law. But I did want to bring up a comment that you had mentioned about specifically, like emergency use and all that, or could there be an emergency? To what level do you believe that you should be able to balance individual rights versus quote-unquote welfare for the people, specifically in dealing with an emergency. And
But, yeah,
because
I think that's what Sam was asking. I think that generally my answer is the same, and that it's not the president's job to balance this. This actually seems like a job for the legislature. But the legislature, I mean, you just saw the AUMF, right? The legislature gave the power to the president to deal with that kind of situation unilaterally. I don't think we've seen something like the AUMF for COVID. So.
I think, yeah, I hate to do this, but I think we've kind of run out of time, so I would just like to thank the panelists.
All I have in my backpack is, oh, maybe I'll take
Yeah, I know I don't. I usually Professor Duncan.
Professor Duncan.
What's an emergency? That's kind of what I thought. What's an emergency? Thank you. I appreciate it. I don't want to keep this.
Like I've read about
I know.
I will.
Right, I was like,
I know what Rob says.
I'm on the back, and we just.
I gotta get to class.
I gotta get to class.
Recording, like, we were just, you know.